Good morning, good morning, good morning. It is, I don't know what day it is. It's travel day. It's Thursday, November 2nd. Can you believe we're already in November? I can't believe we're in November. I'm not okay. I'm unwell about us being in November. So, replay crew, love you. Everything will be time stamped down below. It's going to be a basically a single subject stream, but we are going to cover the Keffe D Arraignment at the end of it. If there's video, I don't know if there's going to be, but if not, news articles have already reported what's happened at the arraignment, so we'll tuck that away at the end, because yesterday Alec Murdaugh and his legal team filed a new motion to remove Judge Newman from this case. So we're going to have to talk about that and cover that motion. You may have seen in the news that they filed their motion for new trial. If you remember, we already went over their motion for new trial, because when they filed their notice of appeal asking, or their notice to stay the appeal, asking the appellate court to send it back down to Judge Newman, they attached their motion for new trial to it. That was all the courthouse Becky stuff was in that motion for new trial. So that motion for new trial has now been filed back in the lower court. So it's the same motion that we've already covered. It's now officially filed in the lower court. They filed that on October 31st. But what's new is Poot et al. Asking the South Carolina Supreme Court to remove Judge Newman from all of the Murdaugh cases. So that's what we're going to cover first today. Then we'll swoop back around at the end and cover the real quick information from the arraignment from Keffe D, who is accused of killing Tupac Shakur. So that's what we're going to do today. I am already feeling it. This is why Vegas kills me. I cannot come to Vegas and not feel crusty. I have been here like for a half of a second, and already the desert dryness will kill me. The desert dryness will kill me. It's just, it's how dry it is. It's how dry the air is. And then smoke and stuff in the casinos will get me every time. So we'll see how this goes. But 10-10, I think it's going to be more difficult than when it was in New York. Not as dry, but I am already, like, my eyes are already watering. The smoke gets me with the eyes, but it's interesting. And then because I normally stay at the other end of the strip, in a hotel that doesn't have a casino and doesn't have smoke in the hotel, so it's a little easier. But we needed to be close to where, or wanted to be close to where BravoCon is, because Vegas is already so much walking. So it's bananas. Talia said you can still smoke in Vegas, like everywhere, like everywhere. Like everywhere. Get a humidifier. I forgot to pack mine. That's on the that's happening today. Smoke in the casino. Yeah, in the casino. People are playing slot machines smoking in the casino. So you can't walk through the floor of the casino without there being smoke. I totally forgot it. Well, sometimes it's cigarette smoke. Sometimes it's cigarette smoke. I forgot my humidifier, so that's going to happen today. I also forgot my dongle for my computer. I had lent it to Dr. B so I could hardwire in the computer. I had lent it to Dr. B for something and then forgot to get it back before traveling, because of course I did. So it's wild. So it gives nice ambiance. It's very Vegas. It's very Vegas that there's like, that there's stuff. The Park MGM is smoke free. Sadly, the Park MGM is not close to where I'm going to be. No smoking in the casinos in Atlantic City. It needs to be a thing, but it's fine. I just, my body is not prepared. We're not prepared. We're not prepared for it. It just gets to me. So I will be hydrating like everything today. And then I have to also apologize to y'all, because last night after dinner, by the way, we were at the same restaurant Andy Cohen was for dinner last night. So he's walking by and he kind of looked at our table and we're like, "Hey, Andy." And he's like, as he was leaving the restaurant, it was too funny. Like, that's how you know you've picked the right restaurant for the night, when Andy Cohen and his like entourage go walking out. It was too funny, but BravoCon. So when, what was I saying? I have no idea. Oh, apologies. So last night, went to dinner, had a great dinner, had delicious like Japanese whiskey highballs. They were so good. But by the time I got back to the room and was getting wound down, I was like, oh, I haven't populated the stream yet, and meant to populate it so it went live at 11 Central. and went to do that and just did not get it right. The way I realized that the stream was set for the wrong time was because my app notification came through. Like, I saw the app notification, it was like, live now, and I was like, no, I'm not. I'm not. I'm supposed to be live in an hour. Like, I saw my under eye patches on. Like, I'm supposed to be live in an hour. I'm supposed to be live in an hour. No. And that's the moment I realized. It's like, that's the moment she realized she fucked up. I was like, I must have set the stream wrong. The app notification saved my life this morning. So thank you, Team Baker, for the app notification, because that's how I realized I had set the stream for the wrong time. So y'all weren't just sitting in the stream waiting for me. I could come into the stream and be like, hey, I set it for the wrong time. We'll reconvene in an hour. My bad. It's like the year I forgot that the time changed and showed up everywhere an hour off. So I am so sorry about that. It's traveling. Bookish said, seriously, Emily having these moments makes me feel normal. I look, life is life. There are things I mess up all the time, and I mess things up. It totally happens. Everybody does. It's so human. But I was so mortified because I felt bad for y'all who were like, live is starting. Like, I don't want you to feel like we've got to go. It's time for live, and then no live. I felt so bad. So apologies, chat. That was completely my bad, but the app saved me because that's how I realized that I was running late. So if you do not have it yet and you want to stay in the loop, especially if you are a member and have not downloaded the app yet, please make sure you do, because when I do behind the scenes members only stuff this weekend at BravoCon, I am going to be notifying you through the app. The information about where we're doing our Vegas meetup is in the app. It's going into your like DM space in the app. There's like a push notification that goes to you. That is in the app, not just the app notification. So that information is coming to you through the app. So if you don't have the app, you will not have that information because I'm not posting it anywhere. So that's what we're doing. Lisa said, I'm still mind blown over the book Miss Becky was able to write about as a court official. If any of us JAs tried that, we would be in so much trouble. The Netflix interview is mind blowing too. I have not watched the Netflix interview yet. I'm considering listening to the Netflix or watching the Netflix interview and reading the book. But yeah, JAs would never get away with that. And Lisa, thank you for your work. JAs make courthouses run. You know that. JAs, for everyone in the chat, like, what? Judicial assistants. Great judicial assistants, like them and their judge are, you can see them like reading each other's minds. Like, they just know each other so well. A great JA is critical to the smooth running of any courthouse. So, Nicole says it comes across as a gossip session for her. Oh yeah, Courthouse Becky is just like, oh my God, you guys. Oh my God, you guys. So we went to Moselle, like, and the jurors were there too. And we read each other's souls. Like, I could see that they knew, like, when we got to Moselle, like, they could feel it coming in the air tonight. Like, they knew that he was guilty. Like, oh my God, like, what? Yes, that's exactly. MB said, I don't believe that the book she wrote is true. It might not be, but it won't matter. The fact that she alleged that she had these communications is going to be bad enough. So I think we've got a huge problem with that, which is why the motion for new trial is going to be so interesting. I can't wait. The app is great time blindness friend. It is. Brenda says ethics gave Miss Becky permission. I have not pulled up the ethics letter. I think maybe there was some miscommunication exactly what they were giving her permission for. So ask the hotel for a humidifier. Oh, I will. I will absolutely ask them. I didn't even think to do that. Thank you for the tip. You guys are great. I have travel tips, but those are not them. So Joe said, I love Judge Newman. Do you think Judge Newman will be removed? Joe, that's what we're going to talk about today. So, sounds hilarious with Raspy Smoker's voice. I mean, that's my Vegas voice. It's like, oh my God, what? That's all I've got today. She's not a regular mom. She's the cool mom. Yeah, Miss Becky's like, I'm not a regular court clerk. I'm I'm on Netflix. I'm the cool court clerk. Miss Becky, that's not a flex. Everybody's on Netflix these days. They'll let anybody on there. Let's roll the intro. Let's get into it. We're going to pull up that motion. That's most of what we're going over today. And then I have to preserve my voice because I'm sure by like Sunday I'm going to be thrashed.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
I saw the Vegas is just a free voice changer. Alicia, that's exactly what it is. All right, let's go ahead and pull up the Writ of Prohibition that was filed. This might look a little smaller than when I have my multi-screen setup, so apologies if it is difficult to read. I will do my best. Mobile setup is not always easy. But you know, we're still here. So we've got that going for us. We've got that going for us. Alrighty. Let's do this. All right. Go. Wait. The hard thing about navigating when I am traveling is that I can't always see the screen I operate from and the document at the same time. So now we should be able to see the document well. Miguelina, just let me know how we look in the private chat because I can't see me, and I want to make sure that y'all can see this as best as we can. So I don't think I can make that any smaller. All right, let us get into all of this. We should have gotten on the plane. We didn't get onto the plane. We should have traveled to South Carolina. That's what we forgot to do. We forgot to travel. Buckle up, y'all. We need to get to South Carolina. All right, away we go. This is filed in the Supreme Court of South Carolina, not the Court of Appeals, not the Superior Court or the District Court where the trial was held. The Supreme Court. This is Murdaugh versus Judge Newman in his capacity as Circuit Court Judge, not as an individual. So you will see, you know, they've designated very clearly that this is what they are dealing with, or they are dealing with Judge Newman in his official capacity. So we've got Harpootlian and Barber are at Poot's firm. I didn't realize Griffin was at a different firm, Griffin Humphreys, and they're all, you know, they're all on this petition. So let's start going through this thing together. All right. Pursuant to Rule 245B of the South Carolina Appellate Court Rules, Petitioner Murdaugh hereby petitions for a writ of prohibition to issue in the original jurisdiction of the Supreme Court, prohibiting the Honorable Clifton Newman, Circuit Judge, from adjudicating Mr. Murdaugh's pending motion for new trial or presiding over future trials of indictments against him. That's what they want. Real clear statement of what they want. They want to yeet Judge Newman for everything. They want to yeet Judge Newman for everything. The trial that's coming up at the end of November, every other indictment, because he's got like 100+ indictments, every other indictment, and the motion for new trial. Generally, the judge who heard the trial hears the motion for new trial. Judge Newman presided over a 6-week trial in which Mr. Murdaugh was convicted of the murders of his wife Maggie and son Paul. The basis for Murdaugh's motion for new trial is that the Colton County Clerk of Court engaged in deliberate jury tampering during the trial to advance her own personal interest. The basis for this petition is that Judge Newman has personal knowledge about the Clerk of Court's conduct, which will undoubtedly be disputed at evidentiary hearing on the motion for a new trial. If all of the jurors come in and say, oh yeah, that's exactly what Clerk Becky did, how are we getting to undoubtedly be disputed? If it might not be, but we've already seen the prosecution in their response in the appellate court saying, oh, well, actually, Your Honors, we aren't getting the exact same story that the defense is feeding you in this motion. So we're not like 100 that everything the defense has said is exactly as it seems, which is why I keep saying, you know, if things are true as the defense presents them, then it's different than if it is disputed. And it might be. The fact that they said undoubtedly disputed is interesting to me. They know that the prosecution's going to come in hot. I wonder what else they know. Further, they say, after the jury returned guilty verdicts, Judge Newman made numerous statements in violation of the code of judicial conduct, the code of judicial conduct that require his disqualification from presiding over future proceedings in this matter. These statements include congratulating the jury for returning the correct verdict, statements at sentencing evidencing personal bias, and statements in public interviews after trial, including an interview on a nationally broadcast news program. What interview was that? What happened? Y'all? What happened? Tell me. Tell me what happened. What interview did Judge Newman do? Did we miss it? Did I miss it? I might have missed it. Were we busy? We've been busy. Anyway, we're going to have to go find Judge Newman's interview. That's for the Today Show. That's for next week. That's for next week. We'll have to do that next week. All right. Okay. We'll do that next week. Some of you are like, GMA or Today Show or something. I don't know what we were doing. We'll go look. We'll go look next week on Tuesday. Let's see. Including an interview on a nationally broadcast news program in which Judge Newman stated his personal opinion regarding Murdaugh's guilt. That's a problem. Legal issues on appeal, and strategic choices by Murdaugh's counsel during trial. He shouldn't have commented on the case until, other than saying, this was a fair trial, it will go on appeal. The case is still open about it. Mr. Murdaugh's right to have his case heard by an impartial judge will be violated if Judge Newman proceeds to hear his motion for new trial. Ordinary appellate proceedings will not be able to remedy this violation after it occurs. Thus, Murdaugh's only recourse is to preserve his rights, is an extraordinary writ of prohibition from this court to prevent the violation from occurring. They are trying to get the court to block Judge Newman from hearing this motion because once it happens, the shit's out of the horse and there's not much they can do, which is why they're saying there's no other remedy for this. Statement of the case. Mr. Murdaugh is a disgraced former attorney and drug addict. I mean, okay. Okay. Defense. Once a prominent member of the bar, Mr. Murdaugh is charged with stealing millions. Millions from clients and others who trusted him, and he gave millions to violent drug dealers who fed his voracious opioid addiction. They're really leaning into drugs made him do it. Like, they're really leaning into drugs made him do it. There's no evidence, by the way, that he gave millions to violent drug dealers. Like, at all. But the fact that they're going, this is the defense motion. Okay. He gave millions to violent drug dealers who fed his voracious opioid addiction. His law firm confronted him about his thievery. I need my soundboard. His thievery on September 3rd, 2021. I mean, it's good use of thievery. He resigned from the firm, and after a failed suicide attempt. Was it though? Or was it insurance fraud? Okay. And after a failed suicide attempt assisted by his drug dealer, entering drug rehabilitation. He was arrested immediately upon leaving rehabilitation and has been incarcerated ever since. 3 months later, on June 7th, Mr. Murdaugh's wife, Maggie Murdaugh, and younger son, Paul Murdaugh, were brutally murdered at approximately 9 p.m. at the dog kennels on their rural family property in Colton County, commonly called Moselle. We know the details. I'm not getting into the fact that they have now, with Attention to detail described the murder, but you've got to, I guess, lay the stage. Murdaugh was indicted. Murdaugh was indicted for the murders. It's so hard to say those two words together. On July 14th, 2022, the state alleged Mr. Murdaugh was confronted at, was it July? Wasn't this a winter trial? Because I was streaming Murdaugh from the road when I went to go see Dave in Arizona. I'm confused. Maybe it was. Time is squishy. What day? It's November 2023. Was he? Oh, that was the indictment, not the conviction. Just kidding. We're okay. Okay, let's back up. I was like, wait. Murdaugh was indicted for the murders. Oh, that's helpful. Wait, come back here. Murdaugh was indicted for the murders on July 14th, 2022. The state alleged Mr. Murdaugh was confronted at his law firm earlier that day about missing attorney's fees. Then he came home and decided to kill his wife and son that night to temporarily distract the bookkeepers from investigating those fees and reduce his financial exposure in a negligent entrustment suit filed over 2 years earlier. That's the boat crash. Regarding Murdaugh's boat, which Paul allegedly operated while intoxicated, resulting in the horrible death of a young woman, Mallory Beach. To prove the alleged motive, the state was allowed to present weeks of testimony about Murdaugh's many financial crimes, which were otherwise unconnected to the murders. Well, if they're motive, they're connected, but that's the point of being the defense. You get to argue that. Murdaugh vehemently denies murdering his family. There's no direct evidence of Murdaugh's guilt. Direct and circumstantial evidence are weighted the same. There's no witness to the crime, no videos or photos of the crime occurring, no recovered murder weapons, no blood or DNA establishing guilt. There is only circumstantial evidence, much of which is inconsistent with him being guilty. No murder weapons were recovered. The blackout cartridge cases recovered matched extractor marks, but not firing pin impressions on cartridge cases recovered from the family firing range, so the matches are unreliable. No human blood or significant amounts of gunshot residue were found on Mr. Murdaugh or his clothing, despite him only having about 11 minutes to clean himself thoroughly, depending on which timeline you go with, according to the prosecution's theory, footnote 1. Originally, the state was going to argue that the t-shirt Mr. Murdaugh was wearing that night was stained with blood in high-velocity impact spatter pattern that could only come from being next to someone being shot. The evidence was leaked to the general public a few weeks before the indictments were returned. Apparently, the Attorney General's office, given the leak occurred, by the Attorney General's office, given that the leak occurred months after SLED began working with an external blood spatter expert, but less than a week after the first meeting in which SLED disclosed that work to prosecutors. However, it turned out that evidence was fabricated and the state was unable to present it to the jury. In closing arguments, prosecutor Metters explained, quote, "And they're putting these law enforcement on trial, talking about blood evidence, talking about other things that were presented to the grand jury, which that blood evidence was investigated and the state didn't offer it. That's what you do when you're a prosecution. Don't try to offer it." I don't even remember that from Metters' closing. I'm sure some of you might, but that came up a lot because there were issues with the blood spatter analysis. Absolutely issues with the blood spatter analysis. And again, that's why it didn't come in. There was a water hose at the kennels, but it remained coiled on the wall mount in the exact manner seen in Paul's video taken only moments before the murders. That the murders were close in time and place, but used different long guns suggests multiple shooters. Unidentified male DNA was recovered on Maggie. Maggie's cell phone was taken from her when she was murdered and was later thrown onto the side of Moselle Road, half a mile from where her body lay. No explanation was offered as to why Mr. Murdaugh would take Maggie's phone, for which he had the passcode, but not Paul's, for which he did not have the passcode, or why he would throw it to the side of the road near his home. GPS data from Mr. Murdaugh's cars shows that if he did throw it, he must have done so while his car was traveling approximately 40 miles an hour. Yet, without the phone recording any event associated with physical movement. I think the timeline on that wasn't super clear either, but that generally cuts against the prosecution. If it's like, well, it could be this, it could be that, that generally goes towards the defense. It's unlikely the phone could have been thrown. I mean, the jury gets to decide that. It's unlikely the phone could have been thrown from a moving car at 40 miles per hour without causing the phone to record any event, given that merely picking up a phone or rotating it 90 degrees causes a recorded screen on event. Well, they did bring in an expert who was like, I tossed my phone around in my office. That was a mess. That was a mess. Mr. Murdaugh called his wife several times after she was murdered. The last event ever recorded on her phone before it was recovered, other than missed calls and messages, was a physical rotation during one of Mr. Murdaugh's calls, suggesting the phone was thrown in response to his incoming call. I mean, that's their theory. Moreover, the state's expert admitted that if her phone and Mr. Murdaugh's phone were at the same point moving together on the same person, he would expect to see, quote, step data on both phones in about the same time span. This, I thought, was very powerful evidence for the defense. You would expect to see step data on both phones in about the same time spans, but that there was nothing indicated on the phone. There was nothing that indicated the phones were moving together, which I found to be very interesting. They're just going through, and again, I don't know if they need all of this in their motion regarding Judge Newman, but they want to remind the court, hey, this case isn't a slam dunk case. The calls made by the judge absolutely matter. While driving to and from his mother's house, Murdaugh had multiple telephone calls with several people who found his affect completely normal. Everyone who knew them, everyone who knew them testified Alec, Maggie, and Paul had a normal, loving relationship. I mean, as much as one can know what's going on inside someone's home. The motive, the state alleged, was implausible and nearly abandoned by the state in closing arguments after it served its purpose of justifying weeks of testimony about Mr. Murdaugh's financial crimes. It was a lot of testimony about financial crimes, to the point where we were having those conversations regularly, like at some point too much comes in, but those motions have already been denied. And that hasn't come up on appeal yet. So the motions for new trial on, like, you let in way too much financial data, too much bad acts data, or information, that hasn't come up on appeal yet because Miss Becky's behavior intervened. So this is part of the state's closing. Mr. Griffin goes, does that motive make sense? It did in his mind. His world is collapsing. His world is coming down. This is the only way he could save. It's the only way he could save Alec. But if you don't, if the motive, well, I don't know, is that enough? Is that enough? Is this the closing? Whose closing is this? We don't have to prove motive. We're certainly there. That's just one explanation. I always have said if there's multiple explanations, it tends towards reasonable doubt. For any jury, it's like, well, it could be this, it could be that. Most jurors are like, if it could be this, it could be that, then don't I have doubt as to what it is? Which is the danger of trying to prove motive when you don't need to prove motive. We're certainly there. That's one explanation. But if he's down there and he's angry, this don't sound like a real jovial. And, oh, this must be matters because now we're talking about Bubba. Bubba, a dog. Don't let me forget about Bubba. I remember this moment of closing. This was a very dramatic moment of closing when Meadows was like, Bubba, come here. Like, he was like in motion. He was like on stage. I remember that when he was like, don't let me forget about Bubba. Bubba, come here. Maybe he just got angry. Maybe he got angry at Paul. Maybe he got angry. You know, we all start all of this with the boat case, and maybe he just lost it. Maybe he just lost it. Maybe he wanted it to look like a suicide, and then Maggie came and he had to shoot her. I don't know. When the prosecutor is telling you, I don't know, in the closing argument, again, it generally goes towards, well, if you don't even know, how is the juror supposed to not have any doubt? But I remember when he yelled, Bubba, come here, that all of us were just like, it was terrifying. Only one person knows, and that's why we've got the motive. That's why we say he did it. But we don't even have to have motive, just angry, he did it. In post-trial interviews discussed at length below, Judge Newman admitted his decision to let the state present weeks. I mean, I don't think it was weeks, but it was definitely interspersed, and I think it did take up at least a full week. Weeks of testimony on Mr. Murdaugh's financial crimes was, quote, pretty controversial. Well, I mean, to you, Bubba, come back. It scared the crap out of me because he all of a sudden was like yelling. I don't know. It definitely woke me up. The evidence presented at trial would appear to present a Gordian knot requiring extensive deliberation to untangle. But the case was submitted to the jury at about 3:45 p.m. on March 2nd, 2023, and a verdict was returned early that evening. Jurors' television interviews indicate the actual deliberations took less than an hour. Sometimes murder cases are like that. On the last day of closing arguments, the same day the verdict returned, one juror wore a suit and coat for the first time during the 6 weeks of trial, which was obviously not his, as it was many sizes too large, and he recorded an appearance on national television that very night. Chat, is he implying that the juror knew they were going to come back with a verdict like this and was ready for his interviews? Because it seems like that's what he's implying. Or maybe that's what happened. Maybe it doesn't even need to be implied. It's like, why would you show up in a suit to the very last day of trial if you don't know how long deliberations are going to take? And maybe that's true, that the jurors were like, we're going to be on TV tonight. That leans towards what the defense said about Miss Becky telling everybody that they were going to be interviewed. Which, if Miss Becky was telling everybody they were going to be interviewed and somebody shows up dressed differently, it seems that perhaps they did have that on, the top of their mind when they were getting dressed. I think it's a fair question. Courtney said, why wouldn't they show up in a suit? Jurors normally dress kind of the same day in and day out. So it was not the fact that they were in a suit. It's the fact that in 6 weeks, they were never in a suit. And then that last day, they show up and are in a suit. That's what's being prepared means. Wear a suit just in case you're going to need it. So, anyways, that's what they are looking for. This jury knew that they were coming back with a quick verdict and were ready to be on TV. That's what he's implying. When the jury returned its verdict that evening, Judge Newman congratulated them on reaching what he saw to be the correct verdict. Quote, the verdict that you have reached is supported by all of the evidence pointing to only one conclusion, and that's the conclusion that you all have reached. So I applaud you all for, as a group and as a unit and individually, evaluating the evidence and coming to a proper conclusion. At the time that the judge said this, I remembered saying, I wonder if he says that in all cases, no matter how they come back. Which would be an interesting thing. Does Judge Newman say this in all of his cases so that the jurors feel that they've gotten it right? Being on a jury can be tremendously stressful. Passing judgment in a heavy case can be tremendously stressful. So I wonder if this is his regular course of practice. We'll see. Murdaugh was sentenced the next day. When sentencing Murdaugh, Judge Newman repeatedly expressed disdain for Murdaugh's denial of murdering his own family. Oh, he definitely did that. Mr. Murdaugh filed a notice of appeal March 9th. 19 days later, on March 28th, Judge Newman gave a lengthy public interview about the trial to his alma mater, the Cleveland State University College of Law. In the interview, he expressed opinions about defense counsel's decision to seek a jury view at the murder scene. Quote, and it ended up, I thought, being helpful to the prosecution and not the defense, though requested by the defense. I mean, they came back with a pretty quick verdict. You can assume anything that they did was helpful to the prosecution. He expressed personal opinions regarding Murdaugh's guilt. Quote, but he committed an unforgivable, unimaginable crime, and there's no way that he'll be able to sleep peacefully. Judge Newman said that in sentencing Murdaugh too. Like, basically, I hope you're haunted by what you've done. He definitely leaned in at sentencing. Though, some of this should not be said while an appeal is pending. And I like Judge Newman a lot. But even if he had said he was convicted of committing unforgivable, unimaginable crimes, it's really hard when cases are pending appeal. He also explained his reasoning for his decision to allow weeks of testimony on admitted financial crimes unrelated to the murders, which he knew would be a central issue in the then pending appeal. Later on, and shortly before June 21st, Judge Newman gave another interview on the Today Show, a national broadcast, again expressing his I think they mean personal, but it says persona opinions regarding Murdaugh's guilt. Quote, "I cannot imagine him having a peaceful night knowing what he did. I'm sure if he had an opportunity to do it all over again, he'd never do it." On August 1st, the Colleton County Clerk of Court, Becky Hill, published a book, Behind the Doors of Justice, about Murdaugh's trial. The book was a final straw that led to some jurors coming forward to describe Miss Hill's jury tampering. In brief, what have we learned? It's never brief. It's never brief. In brief, jurors stated that after the state rested and the defense began its case, Miss Hill entered the jury rooms often, telling jurors not to let the defense throw you all off or distract you or mislead you, and telling them not to be fooled by Murdaugh's testimony in his own defense. And then they cite their motion for new trial that's attached. She had multiple private conversations with the jury foreperson. If that is true, that is done. If that is proven to be true, and again, as officers of the court, the defense shouldn't be putting forward anything that isn't true. But also, I want to be careful because I don't want anyone being like, oh, he's getting a new trial. We need to see what happens. If that is true, they will get a new trial. Marissa, this is a great question. Marissa said, doesn't the presumption of innocence go away on appeal? Well, after they've been convicted, the presumption of innocence is gone. But it seems as though the judge is giving his personal opinion as to guilt. Not saying the jury found this, the jury decided that. He seems to be giving his personal opinion as to guilt. And if he is convinced that Murdaugh is guilty, and he's stated that he believes Murdaugh is guilty, and Murdaugh is granted a new trial, which is a very real possibility here, given what's going on with Miss Becky. How can you have a judge preside over a new trial when the judge has already expressed that they believe the person's guilty? Judges are supposed to be neutral arbiters. So if a new trial is granted on the murders, you might need a new judge on the trial on the murders, because he seems to be giving his opinion that Murdaugh is guilty. And you can't have a neutral arbiter on the murders when he's saying Murdaugh is guilty. It's harder on the financial crimes because he's admitted to the financial crimes. He's still going to trial on them. He's admitted them. But Judge Newman hasn't commented on those. They go on to allege that Courthouse Becky fabricated a Facebook post in an attempt to remove a juror she thought might vote not guilty. That's all speculative. Who was removed on the last day of trial for a different reason. Judge Newman even stated on the record in-camera proceedings, oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me. That is a problem. After Judge Newman made that comment, well, did he make that comment to Miss Becky? After Judge Newman made that comment, Ms. Hill interrogated the juror again about her views on the evidence presented and the views of other jurors. When the jury began deliberating that evening, Ms. Hill told them, quote, "This shouldn't take us long," and that if they deliberated past 11 p.m., they would be taken directly to a hotel, even though none were prepared to stay overnight. Which is wild because they weren't told they were being sequestered. So I don't even think you can do that. The insinuation is that she was incentivizing the jury to come back with a quick verdict. She told the jury they would not be allowed to take smoke breaks as they had previously been allowed to do during the 6-week trial. There were 6 smokers on the jury. She told jurors that after the trial they would be famous and predicted that the media would request interviews with them. She even handed out reporters' business cards to jurors during trial. And she traveled with jurors to New York when they appeared on the Today Show. New York City! On September 5th, Murdaugh filed a motion to suspend his appeal for leave to file a motion for new trial based on the evidence of Becky Hill's jury tampering. Attached to his proposed motion for new trial as an exhibit with supporting affidavits. On October 17th, the court granted the motion, order State v. Murdaugh, appellate court, and then they list the order. Mr. Murdaugh filed his new trial motion on October 27th. Judge Newman is currently assigned to decide the motion. So, I think it was a pretty good summary. I mean, it's advocacy, right? So it's the defense's version of things. But the Becky stuff is wild. And I think the reason that they are fighting here is because there is a real possibility. Most of the time you look at this stuff and are like, good luck with your new trial motion. With this one, I look at this and I'm like, you have a real possibility for a new trial. If even part of it is true, you get a new trial. And so they're arguing that Judge Newman has expressed his opinion as to guilt and he can't oversee a new trial and he should not be allowed to oversee the new trial motion because of that. Why is my phone not in Do Not Disturb? I put it in Do Not Disturb. It is, I am disturbed. Stop it. Do not disturb me. We're streaming about the murdacity of it all. Legal standard. This is what they have to prove. How quickly would the new trial begin if granted? Not quickly at all. It could easily take over a year because they would have to find time for a 6-week trial and they would start doing the motions in limine all again. So a year. Your streak continues. You travel and other cases go to what the fuck mode. I saw that the Maya case is in full WTF mode. But Rob's covering that. We can talk about that in Q&A. I was watching Rob's coverage of that last night while I was getting ready for dinner. It was so good. Legal standard. The Supreme Court may issue writs of prohibition in its original jurisdiction. A party may seek issuance of an extraordinary writ in the original jurisdiction of the court by petition. Quote, oh dear, what year is this case from? What year is this case from? Quote, the ancient prerogative. The ancient prerogative writ of prohibition has been recognized and employed in the common law system of jurisprudence for more than 7 centuries. And like all prerogative writs, should be used with forbearance and caution and only in cases of necessity. If the Supreme Court does not write, it's my prerogative, when they issue whatever ruling they're going to issue, I will be very, very sad. It's my prerogative. It's like my opinion. The fact that this quote starts with the ancient prerogative is, I need to know what year this case is from. Wait. Is this the one from 1938? At least it starts with a 19 instead of a 18. Okay, let's get back. Let's get back to what we were doing. Apologies all. Okay. Let's pull this up. Let's embiggen the document so y'all can see it. Quote, it is primary and it's a primary words. It's primarily a preventative process and is only incidentally remedial. The writ, quote, will be granted only to prevent an encroachment, excess, usurpation, or improper assumption of jurisdiction on the part of an inferior court of tribunal, or to prevent some great outrage upon the settled principles of law and procedure, and that case is from 1938. So wait. The writ we're talking about is completely established, it seems, by case law. So trying to determine what the standard is here is difficult. So I think what they're going to argue is the standard is, a judge giving personal opinions of guilt or innocence is an outrage, that there is an encroachment here on the fact that you should have a trial in front of a neutral arbiter. So that's a difficult to parse legal standard. Has this been done? Has this been done since 1938? When's the last time this type of writ was granted? When is the last time this type of writ was granted to remove a judge? I have legal research to do. Argument. The Code of Judicial Conduct requires Judge Newman to disqualify himself from hearing Murdaugh's motion for new trial. Judge Newman has a personal knowledge of the clerk of court's alleged misconduct, and this is another problem. If there are these issues with Miss Becky, the court's a witness to the new trial motion. And that's a problem. Quote, a judge shall disqualify him or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where the judge has personal knowledge of disputed evidentiary facts. This judge may have personal knowledge of disputed facts, and I think it would be hard to argue that he doesn't have personal knowledge of disputed facts on the new trial motion. Because they have him saying in chambers, I'm really upset that this clerk interrogated a judge. Or interrogated a juror. A juror. So as much as I love Judge Newman, I agree with the defense. I don't know how Judge Newman presides over the motion for new trial when he may be a witness to the new trial. Right? Beaker said, question, but aren't Poot and Jim witnesses too? Yep, they sure are. And they should probably have Barber doing the motion for that reasons. He knows she interrogated the juror. He does. But if he knew, wouldn't he pull out of the case? Wouldn't he disqualify himself? They're arguing that he should. Rando from Iowa, two things can be true at once. I love seeing Judge Newman preside, but there are rules. Should Judge Newman have conducted an investigation about the misconduct of his clerk of court? It depends what else he knew. Possibly. What happens if everyone in this case ends up a witness? It's a bigger deal when it's the judge. Aren't they worried that if Judge Newman isn't taken off the case, they'll piss him off? They've got to roll the dice on this. He's also close to retirement, so there's going to be considerations about whether or not he would be allowed to sit for this in retirement or not. I don't think they care about pissing him off at this point. I really don't. All right. For example, we just talked about this. Emily, keep reading. For example, in-camera testimony, statements made in open court, and excerpts from Becky's book indicate that Becky told Judge Newman about the Facebook post purportedly made by the juror's ex-husband, claiming that this juror discussed her opinions about the evidence to the ex-husband. Becky at some point claimed that the post had been deleted, and as evidence, she provided an unrelated, quote-unquote, apology post by a person coincidentally having the same name as the juror's ex-husband. Turns out that no such Facebook post was made by anyone associated with the juror, and that it never existed at all. That's a problem. Statements made by Judge Newman during an in-camera hearing involving Juror 785 indicate that Judge Newman and his law clerk had multiple conversations with Juror 785 and that the clerk of court that are not reflected on the record. That's evidence. Judge Newman stated on the record the evening of February 28th that, quote, "I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me." At one point, Judge Newman indicated that he wanted to speak with the clerk of court about her knowledge of the Facebook posts. Quote, "Of course, the clerk, I would want to hear directly from her, because when she indicated that she had read a Facebook post over the weekend referencing this is Friday, and she just mentioned it today." Judge Newman's personal knowledge of her actions about the juror is relevant to the clerk's credibility if she disputes the representations made by other jurors that she engaged in inappropriate communication with them. As a result, Judge Newman must be disqualified under the canon of judicial ethics. It's a problem. This is not a nothing burger. This is a problem. Murdaugh raised the issue with Judge Newman via letter. Oh, it's attached as Exhibit F. Chat, remind me that we need to look at Exhibit F, please. Don't let me forget. I want to see what they put in this letter. Please, please, please. Julia said, Amazon the computer dongle to hardwire. See, I realized this morning that it was missing, so as much as Amazon is amazing, I don't think that they could have gotten it to me in that amount of time, but I am going to be ordering another one. So do not worry. This is a deluxe burger with extra cheese. This is a double cheeseburger, hold the lettuce. It's a double cheeseburger, hold the lettuce. Don't be frontin' son, no seeds on the bun. Oh my God, one of my favorite YouTube videos ever. Back in the day. Amazon has a warehouse in Vegas. They're like, you'll get it faster than you think. Okay. Exhibit F. We have to do that next. The state responded with a letter asserting Judge Newman's knowledge of these facts. The state responded with a letter asserting Judge Newman's knowledge of these facts is not critical or unobtainable by other means, and therefore he need not recuse himself. Letter from Creighton Waters. Exhibit G. The cases cited therein for support are inapposite. State versus Talbert is a 19th century case in which the trial court's decision to disallow testimony from a judge about a warrant issued and against the defendant was affirmed because the judge's testimony was irrelevant. Here the issue is much more unique. A clerk of court is accused of bringing fabricated evidence to a judge in an attempt to influence the jury's verdict to achieve personal fame and money in a high publicity case. But the issue is not whether Mr. Murdaugh may call Judge Newman to testify at an evidentiary hearing. The standard for quashing a subpoena to a judge is not the standard for the judge's recusal. It could be the case that the information the judge possesses is readily obtainable from other sources, but that would not change his knowledge of disputed evidentiary facts. He knows. He knows. For example, no one would question the need for a judge to recuse himself from presiding over a prosecution of a crime he personally witnessed, even if there were many other witnesses and the crime were caught on video so that his testimony would be unnecessary. It's a good argument. Here, Judge Newman has personal knowledge of Ms. Hill's representations to him about a Facebook post she said was by the ex-husband of a juror who was discussing the evidence with him during trial. How would Miss Becky even know that that's the juror's ex-husband? Like, why would you even look at the Facebook post and be like, oh my God, right? Like, I totally wonder if that's juror 785's ex-husband. I mean, I guess it is a small community, But still, Judge Newman asked her to produce the post, and she told him it was deleted and replaced with a post apologizing for it, which she did produce. Murdaugh alleges the first post never existed and that she knew the purported replacement post was not by the ex-husband of the juror. Ms. Hill presumably will not admit that, footnote 2. Ms. Hill certainly will be a witness, and she will be asked to bring the Facebook issue to the attention. She will be asked about bringing the Facebook issue to the attention of Judge Newman. If she testifies falsely about that, Judge Newman might know it. If that happens, what then? Would he simply announce that her testimony is incorrect? Would he make a finding of fact based on personal knowledge that contradicts sworn testimony on the record? Such questions are why judges having personal knowledge of disputed evidentiary facts must disqualify themselves. Miss Becky has created a mess because the Facebook stuff happened. We know that. Judge Newman's comments to the jury after the verdict was returned violated Canon 3 of the Code of Judicial Conduct. Quote, a judge shall not commend or criticize jurors for their verdict other than in a court order or opinion in a proceeding. It was, okay. But may express appreciation to jurors for their service to the judicial system and the community, which is what I typically see. Thank you for doing your job. Thank you for reaching a verdict. Thank you for taking the times out of your lives. It's rare that you see a judge say, you got it right. Judge Newman told the jury, quote, I will make no comment now as to the extent of the overwhelming nature of the evidence. I mean, that's kind of a comment. But certainly the verdict that you have reached is supported by the evidence, circumstantial evidence, direct evidence, all of the evidence pointing to only one conclusion. And that's the conclusion that you all have reached. So I applaud you all for, as a group and as a unit and individually, evaluating the evidence and coming to the proper conclusion. The proper conclusion is the problem. Quote, to applaud the jury for coming to a proper conclusion in its verdict is commendation for reaching the right decision in violation of the canon of judicial ethics. The Supreme Court for New Jersey, I don't know if South Carolina gives a shit what New Jersey's doing. The Supreme Court of New Jersey found a judge violated the canon against commending a jury for a verdict when he merely told the jury, quote, your verdict has been adequately and amply supported by the evidence. Judge Newman's comment, quote, applauding the jury for coming to the, quote, proper conclusion, and, quote, the only one conclusion that, quote, all the evidence pointed to is in contrast a much more egregious flouting of the well-known rule against commending or criticizing the jury for its verdict. Further, Judge Newman's use of the word overwhelming to describe the evidence when applauding the jury for coming to the only one conclusion that, quote, all the evidence pointed to was no accident. As the court is aware, overwhelming is a term of art in reviewing criminal proceedings. Trial errors may be deemed harmless if the evidence is otherwise, quote unquote, overwhelming. Likewise, deficient performance by trial counsel is usually not deemed prejudicial if the evidence is, quote unquote, overwhelming. By commending the jury for coming to the only conclusion permitted by the overwhelming evidence, Judge Newman was placing in the record his opinion that if his decision to allow weeks of testimony on financial crimes unrelated to the murders, which he admits was, quote unquote, pretty controversial, is error, it should not result in a new trial. That's a bit of a reach, but I understand the argument. Likewise, in his opinion, any issue raised in post-conviction review should not result in a new trial because it's, quote unquote, overwhelming. So if it's overwhelming, a lot of things become harmless error. What they're accusing Miss Becky of is never going to be harmless error. Ever. Likewise, in his opinion, any issue raised in post-conviction review proceedings should not result in a new trial. Judge Newman broke a binding rule of conduct to opine on the record that any errors discovered in the trial proceedings, whether on direct appeal or collateral review, should not result in a new trial. That shows bias against granting a new trial, even if warranted. saying he used the word overwhelming to preclude appeal is a bit of a reach, but the Facebook stuff is a problem. I understand why they're concerned about. I applaud you for reaching the right decision. You generally don't hear judges go quite that far. In sentencing, Judge Newman kind of went in. He really did. But the biggest problem here is the alleged actions of the court clerk. Judge Newman's statements on Murdaugh's sentencing show personal bias in violation of the canon. Quote, a judge shall perform judicial duties without bias or prejudice. A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice. CEG, the Oklahoma texting judge that I covered last week. The commentary to the canon states, a judge must perform judicial duties impartially and fairly. A judge who manifests bias on any basis in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. Murdaugh denies murdering his family, but does not deny that the jury returned a guilty verdict and that it would be appropriate for the sentencing judge to comment with disapproval on the commission of such a horrible crime. But Judge Newman's comments at sentencing show personal bias regarding Mr. Murdaugh and his family that is well beyond general attitudes common to the public generally about murder. Judge Newman's comments take personal offense that Murdaugh denied committing the murders, which is Murdaugh's legal right. The court's outrage that Murdaugh presumed to defend himself is a manifestation of personal bias. They didn't quote him. For example, there we go. For example, Judge Newman said at sentencing, and you've engaged in such duplicitous conduct here in this courtroom, here on the witness stand. No. This is a bit of a reach. They have some really strong arguments, and then they kill me with the stuff that's like, let's stretch Armstrong as much as we can. That was the judge, that section was the judge commenting on him lying on the stand. Continuing, quote, but amazingly, to have you come and testify that it was just another ordinary day, that my wife and son and I were out just enjoying life is not credible, not believable. You can convince yourself about it, but obviously you have the inability to convince anyone else about that. So if you made any such arguments as a lawyer, you would lose every case like that. I don't think Judge Newman is testifying that Murdaugh's audacity was defending himself and not admitting it. I think it was about Murdaugh lying on the stand. And you're allowed to, look, you can defend yourself at trial and not lie on the stand. You can defend yourself on trial and not take the stand, right? Or you can, tell the truth. Judge Newman did not find his testimony believable, but that's not Judge Newman punishing him for exerting his right to defend himself. That part is a reach for me, but they're throwing everything at the wall to see what sticks. They have some very strong arguments in here. It's not this one for me. They go and say on the witness stand, Murdaugh admitted all of his financial crimes but denied the murder. Judge Newman's comments do not express outrage common to the public generally. Yes, the public, Poot, Jim, I do this a lot. We've watched a lot of trials. The public is generally outraged when they perceive people lying on the stand. That's a general outrage. Let's see. It goes on to talk about Judge Newman's personal outrage at how Murdaugh practiced law for many years, viewing Mr. Murdaugh's denial of murdering his family as a continuation of that dishonest conduct. He said his I'm going to disagree with them on this point. They say that outrage could be judicial bias. I think they've got a much stronger argument that he is a witness to the proceedings. But what was unquestionably personal was the outrage extended beyond Murdaugh's own conduct to the supposed conduct of Murdaugh's ancestors. Oh boy. Quote, even during this trial, the law enforcement has been maligned for the past 5 or 6 weeks by one who had access to the wheels of justice to be able to deflect the investigation. He did have access to the wheels of justice. Don't we think he leaned on those? I disagree. Again, he leaned on his name to be treated better and differently by law enforcement. He was given substantially more leeway than others in a similar situation would have been. Oh, there's a footnote. Hold on. Where did that footnote 3 come from? Where did y'all sneak that in? Where is it? It's got to be up here somewhere. I don't know where they noted footnote 3. Oh, here it is. Mr. Murdaugh did lie about being at the kennels shortly before the murder, which could be called a deflection of the investigation, albeit an ineffectual one, footnote 3. Murdaugh also briefly lied about his attempted suicide because he did not want his son Buster to know he attempted suicide. Briefly. Sir. You should have stopped 3 paragraphs ago. Briefly. They did crime scene sketches. Stop. We should have stopped. Like, we were doing, you had me. As we get towards the end, I'm like, nope, nope, nope. Judge Newman's comment about one who had access to the wheels of justice to deflect the investigation does not refer to him as a criminal suspect who failed to tell investigators the truth. He's talking about why it's more offensive. Murdaugh was rolling around with a badge, a gun, and police lights on his vehicle. You're going to tell me he didn't have access to the wheels of justice? He was the wheels of justice. Should have stopped. Should have stopped while you were ahead. This is the perfect example of stop while you're ahead. Of stop while you're ahead. Stop while you're ahead. They're going on about the wheels of justice. Okay. They say that the comment about that does not refer to Murdaugh's sporadic service as a part-time unpaid assistant solicitor. Look, sirs. Murdaugh treated that position as his own personal, like, I'm law enforcement now. They go on to say it refers to Murdaugh's family as a symbol of corruption in the Low Country, and specifically his father, grandfather, and great-grandfather serving as the solicitors of the 14th Judicial Circuit for 86 years. Judge Newman elaborated on that theme in his sentencing comments, quote, "And this case qualifies under our death penalty statute because on the statutory aggravating circumstances of 2 or more people being murdered by a defendant by one act or pursuant to a scheme or course of conduct. I don't question at all the decision of the state not to pursue the death penalty, but as I sit here in this courtroom and look at the many portraits of judges and other court officials and reflect on the fact that for over the past century, your family, including you, have been prosecuting people here in this courtroom, and many have received the death penalty, probably for lesser conduct." It was a comment on the fact that Murdaugh is still benefiting. He said, "It's not lost on me. What Mr. Murdaugh's grandfather, great-grandfather did in a courtroom before Murdaugh was born is of no relevance to any issue of sentencing. Judge Newman's discussion of Murdaugh's ancestors sua sponte is evidence of personal bias. His sua sponte on his own. His sua sponte discussion of the death penalty is also evidence of personal bias." I'm going to have to think about that one more because you're allowed to comment on the fact that you could have gotten a stronger sentence on this. Judge Newman expressed his opinion that the death penalty would be desirable in this case. He said it was possible in this case, reasoning that Murdaugh should get the death penalty because his family sought it for others who were less deserving of it than him. I think he was pointing out the irony, though. I think Judge Newman was pointing out you're still benefiting Because Judge Newman said your family had the hands on the wheels of justice, and you're still benefiting from that. We're going to Judge Newman's comments, his extrajudicial comments. Sorry, I'm answering Miguelina. A judge shall not, a judge shall not, while a proceeding is pending or impending in any court, make any public comment that might reasonably be expected to affect the outcome or impair its fairness. The commentary to that section provides that the requirement that a judge abstain from public comment regarding a pending or impending proceeding continues during the appellate process. I agree with that. I was surprised that he gave interviews. It's almost unheard of for a judge to give interviews about a pending case, even cases in other jurisdictions. When it does occur, it's almost universally found to be misconduct. And then they cite a bunch of cases for that proposition. Judge Newman did exactly that about Mr. Murdaugh's case on multiple occasions, went on the Today Show to proclaim Murdaugh's guilt before Murdaugh's appeal was even briefed. Shortly after Murdaugh filed a notice of appeal, Newman gave an extended interview about the case to his alma mater. The interview was held in the law school moot courtroom and open to the public. More than 300 people attended, and it was streamed live on the internet. During the interview, Judge Newman expressed his personal opinions regarding Murdaugh's guilt. In my mind, is going to be the problem, because that is an expression of personal opinion. In my mind, no doubt he loved his family. I don't believe that he hated his wife, and certainly I do not believe that he did not love his son, but he committed an unforgivable, unimaginable crime, and there's no way that he'll be able to sleep peacefully. I'm going to need more context on that. We're going to have to watch that interview, I think. But in my mind, it's a problem. So I agree with you guys. You're like, but he was found guilty, but the verdict was already in. But the appeal's not done. So with the appeal not being done, the case is still open. Judge Newman also commented on choices made by the defense, commenting that the defense requested the site visit. The defense opened the door to many other things by the manner in which they presented the evidence. I mean, that's true. He explained his reasoning for his decision to allow weeks of testimony on the financial crimes. And he knew that they would be a central issue of the appeal. Quote, this looks like a Q&A. Quote, hello, Judge Newman. One of the most contentious things that happened in the trial was your decision to allow the financial crimes to come out as inadmissible prior bad acts. No, he determined they were, okay. Don't pick at the question. How did you come to that decision, and what was your rationale for allowing those to come in? Yeah, a lot of it was a lot of it is a pretty controversial decision. And as we will be on the subject of the appeal, and you know the case is final until there's a final ruling on the appellate issue. Oh, no case is final until there's a final ruling on the appellate issue. So I think the record speaks for itself. Initially, the ruling was going to be limited to the things occurring within the res gestae of the moment of the day of the murders, and the lawyers I ruled opened the door to many other things by the manner in which they presented the evidence. Then, of course, once the defendant takes the stand and testifies, then almost everything is fair game at that point. I see why they're arguing on this point. However, I think the judge said the case is not final. The record speaks for itself, and this is what I did. Initially, it was this, and then it was this, and then it was that. Judge Newman declined. This is going back through the examination of Will Loving and his ruling on that. Shortly before June 21st, Judge Newman gave an interview on the Today Show, again expressing his personal opinions regarding guilt. Craig Melvin, do you think he'll be haunted by this, his wife and his son? Judge Clifton Newman, oh, I think so. It has to be. I can't imagine him having a peaceful night knowing what he did. I'm sure if he had an opportunity to do it over again, he'd never do it. Judge Newman gave yet another interview for a podcast hosted by the dean of his former law school. That podcast interview, he discussed Murdaugh's family, speculating that Mr. Murdaugh's family may have been disappointed Mr. Murdaugh never became the solicitor of the 14th Circuit. He also commented on Murdaugh's credibility and culpability during sentencing. Quote, and looking him in the eyes at the moment with really, great empathy for him, he gave himself away. He gave himself a way out by saying it wasn't me. I need more contents for that. In another high-profile case, the U.S. Court of Appeals for the D.C. Circuit held that the trial judge breached his ethical duty every time he spoke to a reporter about the merits of the case. Judge Newman's extrajudicial comments likewise are about the merits of the case. His comments express views on credibility of witnesses, Mr. Murdaugh, the validity of legal theories, and his comments extensively about the culpability of the defendant. And then they go through the code of conduct. It's odd to see a judge commenting so much about a case, and I think it is going to be a problem. But I need more context too. But you generally can't comment about a case. They're arguing that Newman's required to disqualify himself, which he has not done yet. Murdaugh's right to have a case heard by a judge who's not required to disqualify himself. Yes, he has the right to a neutral arbiter. If Judge Newman hears the motion for new trial, his decision cannot be meaningfully reviewed for bias on appeal. I want to get to the exhibits. Conclusion, for the foregoing reasons, petitioner respectfully requests the court to issue a writ of prohibition. What exhibits did we need to get to? I think it was F and G that we needed to get to were the letters. So give me 1 second. Let's go look for those real quick. I didn't want to bore you with all of the transcripts. If we want to go through this more another day, there is more here. There are over 260 pages of this motion. If we want to go through all the exhibits on Tuesday, let me know. It'll be easier when I have my dual screens. So we're not going to do all of that today because it will, A, I'll lose my voice, and B, it is a lot of transcripts. But if we want to go through the transcripts of all the interviews for context, we'll do that on Tuesday. So, Miguelina, can we put up a poll about whether we should go through all of the exhibits on Tuesday, yes or no? Thank you. I can't do it from the laptop. Let's see. Oh, some of these transcripts are long. We're going to need to go through those, I think. I'm only on Exhibit C. D. We're almost there. Jeez. These are exhibits within exhibits. I'm just, Exhibit E. No, we need Exhibit F. Oh my goodness. Sorry, we're going through the new trial motion that's also attached. And that's got its own exhibits. But I want to make sure I don't miss any of these exhibits. We're in Facebook post land. Exhibit F. Here we go. Emily, you know we always say yes. I don't know that. I'm asking. Like, this week's podcast, apparently nobody listened to. So, YouTube is like, fewer viewers are choosing to watch this. So I want to ask you guys about topics. So we're covering stuff that you're interested in. I'm sorry about the scroll noise. I know. I should have moved the microphone. The nature of the laptop. It's better than typing noises, I hope. Like, that's my deepest hope, that it's better than typing noises. I forgot to grab my lip gloss. It's, like, back in the other room. Ugh. All right. We're going to have to keep rolling because I want to get to a little bit of the Keffe D Arraignment and then get on out of here. Okay. Exhibit F. Letter from Harpootlian to Judge Newman. October 18th. Oh, dear Judge Newman, as you undoubtedly know, the Court of Appeals has suspended Murdaugh's direct appeal of the convictions to grant leave to file a motion for new trial. The gravamen of the motion is Courthouse Becky and Becky's interactions with members of the jury that were improper and material to the merits of the evidence presented at trial. The motion does not suggest that you did anything improper during the trial as the presiding judge. Unfortunately, however, Becky Hill's actions make you a material witness regarding her conduct. I think there's some merit to that. For example, in camera testimony about the Facebook post, I'm not going to read the rest of it. We've read that 17 times today. The universal rule is that a witness cannot be the presiding judge. Quote, because of his duties, it is egregious for a presiding judge to testify as a witness in a case being tried before him. Indeed, a judge presiding at a trial is not a competent witness, for the duties of a judge and a witness are incompatible. If he testifies, he would have to pass upon the competency of his own testimony. As a witness, he might be regarded as partisan and would be subject to embarrassing conflicts with counsel. The danger of the dignity of the bench, of subjecting its impartiality to doubt, and of placing the defendant in an unfair disadvantage by admitting the presiding judge as a witness is very obvious. Defendant respectfully requests that you recuse yourself. I don't think it's an unfair request. What do you guys think? I don't think it's an unfair request. I think there is a real possibility that he is a witness here. Let's see what Creighton Waters has to say. Dear Judge Newman, I am in receipt of Mr. Harpootlian's letter requesting that Your Honor recuse himself in the above referenced case. In reply, the state would merely point out that nothing in the law or defense counsel's allegation or speculation would require recusal. Of course, judges should not testify in a case which they're presiding over unless the testimony is critical and can be obtained by no other means. But they shouldn't be presiding over it. Counsel's letter raises no issues which would render Your Honor's testimony critical or such that it could not be obtained by other means. Counsel recalls an exchange which was placed upon the record and otherwise speculates that the court directly admonished the clerk off the record. These matters fall far short of the extraordinarily high bar necessary to justify calling a judge as a witness for matters observed in the course of his official duties, which is also key. These are things observed in the course of the judge's official duties. Furthermore, Canon 3E1A requires a judge to recuse himself when he or she has personal bias or prejudice concerning a party or party's lawyer or personal knowledge of disputed evidentiary facts. But such bias or personal knowledge must stem from an extraordinary source not related to the judge's participation in the case. What they didn't address, though, Creighton. Personal knowledge of disputed evidentiary facts concerning the proceeding. Counsel's letter again raises only issues about which the court, to the knowledge of the undersigned, has only knowledge because of its judicial function, which are tertiary allegations to the core claim that the jury was improperly addressed by a court official, and for which there is significant factual dispute. Indeed, the court was clear at trial that the alleged Facebook post by the juror's ex-husband had nothing to do with the court's consideration for removing the juror. Given the length of the trial and the number of issues raised throughout, properly illuminating another learned member of the bench as to the full extent of the record would be considerable expense of time and effort. The law does not demand, in consideration with any motion defendant may ultimately file in Carlton. So Creighton is like, no, you don't have to recuse yourself, and there are other means that evidence comes in. We will see. We will see what the judge decides to do. I don't think he's going to recuse himself. I'd be surprised if he did. So let's do a quick summary of this and see where our poll's at in a minute. Miguelina, will you end our poll? Let's see how our poll's doing. And let's swoop into a quick summary of this. The defense is asking Judge Newman to recuse himself and or asking the Supreme Court to remove him from this case, from hearing the motion for new trial and any future proceedings. The defense is alleging that Judge Newman has expressed his opinions on the case, though the case is still pending because of the appeal, that he has expressed his opinion as to the defendant's guilt, that he has made other personal expressions of opinion that render him biased to the defendant and cannot hear this case going forward. They also are arguing that Judge Newman is essentially a witness to material facts with regard to Court of Clerk Becky Hill, and he therefore cannot preside over the motion for new trial. That is the heart of the defense's argument. We will go through the interviews of Judge Newman in depth if you would like to do that on Tuesday. Over 1,000 of you voted in our poll. 85% of you are like, go over the exhibits. So we will be going over the exhibits in another stream when I am not mobile, so we can go over them a bit better. But I also wanted to finish up today with the Keffe D Arraignment so we can take a look at that. Because, well, A, I'm interested to see what happens. B, it's probably going to be pretty quick. So we're going to go over that arraignment real quick. So let me pull it up. Thank you, Miguelina, for grabbing the video. Let me pull that up on the proper screen and go from there. All right. Hopefully the sound won't be horrendous. Let's see if I can gain up the sound on this. And we'll be able to see it. Give me 1 second while I pull up the video chat. Let's swoop a doop. Oh no, we need a board. We need a board to Vegas. Everybody, come join me in Vegas. Good to see you guys. All right, let me get this pulled up. Oh, it's in clips. All right, I guess that's the best we're going to do because this is the only video the team has seen. So we're going to go through the clips of the video of the arraignment as best we can. So welcome to Vegas. Keffe D is accused of killing Tupac Shakur. 2 weeks ago, he was in court saying he was hiring his own attorney, and the judge said, if you do not have an attorney on the next court date, I am appointing one for you and we are moving forward. Let's see what happened today in court. Ads? No. No, no. No, no, what we're not doing. This is the judge. The judge has looked to the public defenders and said, are you conferred as counsel? Yes, we are. We can't hear. Uh-oh. I don't know why you can't hear. Hold on. It's because I'm on mobile. Apologies. Let me try to share my screen differently real quick. All right, y'all, give me 1 moment while I fix it, because that's annoying. We need to be able to hear the video. It doesn't help if we can't hear it. Let's see. This is a browser issue. Sorry, chat. We're professionals here. We do our best. Let's see. There we are. No, stop it. Mobile setups are not easy. Let's try this one more time. You guys see how smoothly things go when we're at home, when you see how badly it goes when we're not at home. And I don't know why it is not pulling the audio from the tab. Miguelina, if you have any insight on that, but it's not pulling the audio from the tab. And I don't know why it's not. So let's try this one more time. It looked like it switched to my mic too, which is really frustrating. All right. Let's see if this helps. Maybe, maybe not. Because when it doesn't, Miguelina, allow me to select the audio for the tab when I'm sharing it. So if we can't get the audio going, we're going to have a problem. Let's see. Yeah, Miguelina, if you want to go ahead and do it, because I cannot. I can hear, you guys can't hear. Okay. I'll have you go ahead and share. That would be great. Apologies for that. And we'll just do the two different videos real quick. But the judge is ready to set the arraignment and he enters a plea, so I would like to cover that. So thank you. Miguelina is going to help me out on mobile, which is why we have help, because it won't allow me to select the audio from the tab the way that Streamyard normally does, and I don't know why. So when I went to do that, it was just being silly. And that was really frustrating. And I don't know why. Thank you, Miguelina. Let's roll. I can't hear. There we go.
Mr. Arroyo and Mr. Cano, it's my understanding you guys are able to confirm as counsel today?
That is correct, Your Honor.
Okay, have you had a moment to speak with Mr. Davis about an arraignment?
We did, Your Honor, this morning.
Okay, are you prepared to go forward with the arraignment?
Yes, today, Mr.
Okay,
Davis.
before we get to that, we have one thing. Are you guys taking this to death review? Then, okay, the state is not going to death review on this, so are you prepared?
What the court said was that the state is not taking the case to a death penalty review. So what the judge is telling the defense is, are you ready for the arraignment today? The state is not seeking the death penalty in this case, which is new information for us. So this is not going to be a death penalty case. Okay, let's continue.
Yes.
Okay,
Excuse me.
yes, Mr.
What does
Davis.
that mean?
Okay, I'm asking, in every murder case in every first degree murder case, I have to ask the state if they are going to commit to a committee to try to seek the death penalty. I just asked them that and they said no.
Pause real quick. The judge is explaining this, it seems, to the defendant. It seems that he cut in and said, what does that mean? Generally, a defendant would ask his lawyers, but he's asking the judge directly. And the judge is like, why are you talking to me directly? All right, let's keep going.
That makes sense?
Okay.
Okay, so in light of that, Mr. Davis, sir, what is your full name?
Wayne Keith Davis,
How old are you?
60.
How far did you go in school?
I did like a year ago.
Okay, I'm sorry, what was the last thing you said?
UCLA.
Do you read, write, and understand the English language?
Yes, ma'am.
Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
Yes, ma'am.
Do you understand the proceedings that are happening here today?
Yes, ma'am.
Sir, are you familiar with the one charge that you're facing?
Yes, ma'am.
Do you understand that charge?
Yes, ma'am.
As to that charge, how do you plead, guilty or not guilty?
I'm guilty.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
Wait.
Okay,
Oh,
this case
let's
is
pause
going.
that. So what they just went through is kind of all of the things for a plea. This judge did a great job with, what's your highest level of education? Do you understand, read, write, and understand English? Do you, all of the things to make sure that this is a knowing plea and that he is understanding the proceedings against him. He's competent. He's not under the influence, all of that. And then she said, you have the right to a trial within 60 days. Do you waive or invoke that right? And he waived. Absolutely waive speedy trial, like right now. Just right now. He pled not guilty. So, no, he pled not guilty. He did not plead guilty. He pled not guilty and waived the right to a speedy trial. The state is not seeking the death penalty. All right, let's continue.
Going to be assigned to Department 2. This case is going to have a status check trial setting in Department 2. That date is?
November 7th at 9 a.m.
Thank you, Your Honor.
Okay.
November 7th.
Yes, sir.
Pause that. The defendant he's got a waist shackle on, but he's like, excuse me, Your Honor, looking at the court to talk to the judge. And his defense attorney's like, you have to talk to me though. You don't get, I understand you want to talk to her, but you have to talk to me. So he's trying to talk to the court. He said not guilty. He said not guilty. So he said, I'm not guilty. If we can rewind it one more time. Let's finish up this though, Miguelina, and then see what happens. Let's finish up this video and then go back to his entrance of plea.
Plan on, get Mr. Goodman back on board as my attorney.
Okay, sir, if you choose to do that at any time, Mr. Goodman knows how to substitute in, and that can be done at any time. But for today's purposes, to get this case moving, the special public defender will be appointed to represent you.
Okay, let's go back to we hear the plea. No, he pled not guilty. He asked the court, and I don't know if we have closed captioning on this. He asked the court, when we got to the plea, or no, he asked the court at the end, if I want to hire my own lawyer, can they substitute in? And the court was like, at any time. You're at any time. Okay, let's see if we can get to where he pled, Miguelina.
Okay, the state is not seeking going to
We're gonna have
deputy
to
on
go
this.
forward
So
from here.
Yes.
okay,
Excuse me.
yes, Mr.
What does
Davis.
that mean?
Okay,
Please
I'm
zoom
asking.
past her waivers. A bit further. Because we've got to go past her waivers where she asks him his age and education and everything. So right about there. Oh, no.
What did you
back.
do in school?
There we go.
I did like a year ago.
Okay, I'm sorry, what was the last thing you said?
UCLA.
Do you read,
He
write,
said
and
he did a year
understand
of
the English
college at
language?
UCLA.
Yes, ma'am.
Sir, are you currently under the influence of any drugs,
we pull the
medication, or
captions to the
alcoholic
top?
beverages at this time?
You can do it while it's playing.
Do you understand the proceedings that are happening here today?
Yes, ma'am.
Sir, are you familiar with the one charge that you're facing?
Yes, ma'am.
Do you understand that charge?
Yes, ma'am.
As to that charge, how do you plead, guilty or not guilty?
I'm guilty.
Sir, you have the right to have a jury
Yeah.
trial set within 60 days.
Not guilty. So you have the right to a jury trial set within 60 days, and then he didn't. So that is all of the Keffe D Arraignment. It is set for a status conference November 7th, and in the department it's been assigned to. He pled not guilty. He has court-appointed attorneys. The state is not seeking the death penalty, and he is waiving time right out of the gate. Remember, there's no preliminary hearing in this case because he's been indicted by a grand jury. So this case is just going to go onto the trial calendar. And that's it. That's what's going on with the Keffe D Arraignment. Real quick, arraignments always are. I'm going to go ahead and get to some of the super chats. And thank you, Miguelina, again for pulling that up for me. Let's see. What time is it? Miguelina, we are going to wrap. I don't know if that will work for me later, but if that works for you later, that is fine. Because I've got some stuff I have to do this afternoon, but we'll figure it out. I am less needed. We're working on meeting schedules. Oh, we need to go to our Q&A. Sorry, guys. Look, traveling always gets me. Quick bit. And to prove the point, that's not the Fack Around bumper at all. Aries Scorpion, it's my birthday, my hubby's birthday, and our anniversary. Y'all were like everything on one day. So happy birthdays, happy anniversary. I love it. That's amazing. Tina, thank you so much for the gift of memberships. I appreciate it. Appreciate it so much. Carolyn, South Carolina here. Love your coverage. Thank you so much. It's going to be interesting. It's going to continue to be interesting in the Murdaugh stuff. Very, very interesting. Love an early surprise stream. I mean, it was like, surprise, but wait, we're going to do it at the regular time. Morning, afternoon. How does Alec Murdaugh feel so entitled? His attorneys are doing everything they possibly can. This is an odd case. I've seen all the conspiracy speculation about Becky and if she was in somebody's pocket, because it's so wild that a clerk of court would do this. But it's not like we've never seen people do wild shit before, especially when it comes to money and notoriety. There are times that people just do crazy shit. So I can't just discount it. There are affidavits. We're going to have to see how this evidentiary hearing plays out. That's it. We're just going to have to see how the evidence comes in. It's crazy. The allegations are crazy. But have I seen people do crazy shit? Yeah, people do crazy shit. I watch a lot of reality TV. The things people will do to stay on television. So, Murdaugh is like a bad ex that keeps finding you on Facebook. Just go away, man. And a happy 40th birthday. Pre-birthday jury duty release yesterday. Very good. Very good. Happy birthday. Thank you guys for your memberships. It's great to see you. Thank you for the gifted memberships. We've got a members only later this month. I came in a little late and was ready to fight. I thought Emily was crying at first. No, not crying. I'm just in Vegas. Maybe I'll be crying later. I'm still mind blown over the book Miss Becky was able to write as a court official. We talked about that at the beginning of stream, Lisa. I agree with you. They said it was cleared, but we need to know. I've learned so much from your content. Thank you. It gave me confidence to appeal exuberant driving fines I got as a spicy, undiagnosed teen without a lawyer. I just got the remaining $50K reduced to $2,500. $50K is insane, Deb, and I am so, so happy for you. So happy for you. Just checked our court portal and no new documents filed in the Keffe D case. Also, I'm not seeing video of the hearing, just media requests. Same. Thank you, Just a Paralegal, Leah. That's what we had seen, so we waited until the end of the show to do it. Your travel and shit happens. Bombshell in the Taking Care of Maya case. If you guys aren't watching coverage of the Maya case or are looking to watch coverage of the Maya case, Rob over at Law and Lumber is covering it. I know that Peter Tragos at Lawyer You Know is covering it. And I know their coverage is sensitive to the issues in the case and compassionate towards what's going on in the case while still giving you great legal breakdowns. Both of them broke down the bombshells going on in the Maya case. There are some huge things that have happened that are going to be greatly important to this case. So we will see how all of that plays out as they are in court the rest of the week. So that is who's covering that case. I've been asked why I'm not covering other cases that are going on right now. I really, really try not to cover cases when I'm going to be traveling. Murdaugh, it was unavoidable because the case went over by 3 weeks, and that made it very difficult. But if I'm knowing that I'm going to cover a case, I want to be able to cover from beginning to end as best I can without traveling. Knowing that I'm going to be traveling will kind of lend weight to whether I decide to cover something or not, and that's the case here. I worked nights, so yesterday is 2 days ago and today is tomorrow or something. Cursey nursey, that's how I feel when I travel. Those of us who know you and know you're neurospicy, pretty skeptical that you were going to be live before 9 a.m. Yeah, I think that's very fair. It's like she probably hit something wrong. Yes. I love Judge Newman. Do you think Judge Newman will be removed? I think it's possible that he could be disqualified on the motion for new trial as a witness. But again, as it comes out, if there are other people who were in that in-camera hearing, including all the attorneys, then everybody has personal knowledge of the thing. So it's, did he witness anything else that no one else witnessed? Because it sounds like most of what he witnessed was with the lawyers. But if he had conversations with Becky and no one else was around, it might come up. Do I think he'll be removed from all of the cases? I'll be interested to see what the court does about whether he is expressing opinions improperly outside of court. Because some of those things I'm like, I don't know why you would walk that close to the line. Some of them come close, so it's possible, but he's also retiring. Love getting app notifications. I feel like Emily messages me privately every time. It is messages from us. I do not always type them out. Sometimes our team is doing it. But yes, they are messages from us to let you know personally what is going on. I will be asking the hotel for a humidifier. I didn't know I could do that. Thanks for streaming during your trip. You're welcome. I like talking about these things, and I wanted to talk about this Murdaugh motion and look at it because it's also stuff I need to chew on. There are things there that I'm like, I don't know a lot of judges that would have done this many interviews while a case is still pending appeal. It is going to cause problems. Can't do Murdaugh again, just can't. Well, the end of the month, we're supposed to be in trial with him again, so we'll see. I'm not necessarily saying Alec Murdaugh is innocent, but all of this seems sus. Two things can be true at once. The things going on with the jury are so outrageous to me. It's outrageous. How does it work when it comes to judges' statements? Obviously, they can't while the case is happening, but I'm so confused post-decision. We're not post-decision yet because the appeal is still pending. Until the appeal is final, the case is still open. I remember the judge in Brooks's case had similar sentiment during sentencing. I thought it was normal to express their opinions. Judge Darrow also went in at sentencing a bit more. But yes, judges do express their opinions at sentencing. I can see where the defense is concerned that he applauded the jurors coming to the right verdict, that he's very much talked about the fact that he agrees that Alec Murdaugh is guilty, especially if there's going to be a new trial. I can understand. Again, these lawyers are going to fight everything. Watch Judge Newman and the Nathaniel Rollins trial said the same thing to him. And it might just be this is his practice. And we'll see that come up too. So they dressed up because the jurors knew they would decide quickly and that it was necessary to threaten the jurors to get a quick decision. This is also a very good point, Macadamia Nut. Those things aren't the same. Which one is it? Can Judge Newman be taken off one and hear the other trials? That's possible. It could be, hey, you can't hear the motion for new trial because you might be a witness. Or, hey, if the murder trial comes back, you can't hear the murder trial based on these statements, but it doesn't necessarily mean he can't hear the others. But again, he's on the cusp of retiring. Why didn't the jurors let Judge Newman know what was going on? I don't know. I just don't understand why they all kept quiet about it. There's a couple reasons why, but it's all speculation. It could be that they thought it was normal. Because when the court's like, no one's talked to you about the case, they might think that the court official is like the court talking to them, and that's fine. It might be because it didn't happen to the extent that they're saying it happened. Sorry, I've run out of water. It might be because it didn't happen to the extent they said it could happen. And it might be because they thought it was fine. So we don't know. They're going to have to do an evidentiary hearing. Major cities have same-day delivery. Thank you all. You've been very generous. I will, if I don't get a humidifier from the hotel, I will be ordering one. The judge spoke about his feelings of guilt at sentencing. How is that different or wrong if he is interviewed? He shouldn't be talking about his feelings of guilt overall, other than to say, what you've been convicted of this. But judges do give a bit at sentencing. They have to explain why they're sentencing the way that they are. But the interviews are outside statements before the court is done, and it goes against the judicial canons. There are rules. The sentencing statements are basically the court's only statement on a case because it's a function of their role. Hopefully that makes sense. Poot can argue the same long family history can be used to try to get him off less of a sentence. No, shouldn't be. Rachie71, thank you so much. All right, I'm going to get to a few of our last super chats, and then I've got to bounce. A few minutes behind, but in my mind, he loved, but if he said the jury found him guilty of committing the act, would that have made the comment more acceptable? It's hard to parse, and I don't have it pulled up directly in front of me, but once he's giving his opinion, that becomes something that they're allowed to bring up with concern. Your mods are beyond Bay, EDB. We so appreciate them. I do too. Aren't they great? Did you have the tab muted in your browser? No, I could hear it. You just couldn't. Sorry. Thoughts on yesterday's Maya JHA, Just All Children's Hospital or whatever, Johns Hopkins All Children's Hospital, J Hatch. I don't want to spoil it for anybody that has not watched coverage yet and wants to know, but the defense should have seen this coming. And it's suspicious to me the way the defense tried to not have this come up in trial. I have questions. Sorry for the off-topic interjection, but saw you on Rob's stream last night and just have to know your thoughts on the Maya trial. There are my thoughts. We did that. Brittany next week. I will see if we get to Brittany next week. I hope so. The Maya case got wild this week. It sure did. Welcome to our new members. Thank you so much. Thank you so much. B2, thank you for the amazing gifted memberships. I always appreciate you. You are so generous to our chat and to me. Thank you so much. Thank you for all the gifted memberships, you guys. Thanks for always keeping us up to date with traveling. You're welcome. You're welcome. You're welcome. Our podcast numbers down after BTS. I saw BTS. No, it's just overall, I think everybody's not as interested in the topic. So that's why. Katie said that Runkle is having a charity live stream at midnight tomorrow night. If you guys don't follow Runkle of the Bailey, he does a charity stream every year for a children's hospital local to him. Katie, if you grab that, I'll share it in the community tab as well, so we have it. Yes, we just did that. So yes, we absolutely will. I don't think I'll be able to pop on, but because I'll be here, but it's fair. Ashley, me to my therapist. Sorry, I'm late. I lost track of time. I was listening to EDB. I apologize. I lose track of times, and I had to reschedule a meeting today too, because I ran a little longer than I thought I would. But yes, we will go over new Brittany filings. If you are a member, make sure you have the app downloaded at lawnerd.app.com, because I will be doing some members only behind the scenes stuff and posting it in your members places. I'm going to try doing some streaming onto YouTube vertical while we are out and around. For those of you that are not members and want to keep up to date with what I'm doing at BravoCon and all things like reality TV and me running around like an influencer of some level of nonsense, I will do some of that on Instagram as well if you follow me over there at the Emily D. Baker. But for the members stuff, it's going to be in your members spaces here on YouTube. So absolutely, if you are in the app, and for those of you on Patreon, you'll get links to make sure that you're in the loop. So that is what we are doing. With all of it, Auntie Caddy, I think I got to all of the super chats that were starred. So if I might have gotten through it quickly or earlier, but I do not see it. So I am sorry. I think we got through all of them. So make sure you're in the Law Nerd app so you stay in the loop with what we're doing. I will be back streaming on Tuesday, and then I have some more travel next week. So I think Tuesday is my only stream for next week. With all of that, Law Nerds, I appreciate you for being here. I'm going to go find more water because I am in the desert. And I will talk to you soon. Thank you for being here. Thank you for being Law Nerds. Cheers. Stay hydrated, friends. It's going to be a wild week, I think. And that's going to be interesting. But I will see you in the next one.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.